Thank you, Professor. Dear colleagues, thank you very much for the possibility to speak and to learn during this conference. I was not the member of the group in the last months, but I had the great pleasure and opportunity to be in the first team of Professors Network 3 or 4 years ago. That time I couldn't take part in the conference in person because of personal reasons. So I wanted to, let's say, fulfill a debt today and to speak about the topic of elder people from the perspective of private law. The title is The Ideas of International Unification of Cross-Border Civil Law Measures of so-called Protection of Adults. I would add as an element of relevant private law aspects of so-called aging society and so-called protection of adults. What is the current state of play? We have an increased duration of human life, over 1 billion people over 60 years old. Then in European Union, as this report says, the duration of human life in developed countries is steadily increasing, what is accompanied by increased incidence of age-related diseases. And look at the forecasts made by the Economic and Social Councils, according to which the number of people aged over 60 will increase in European Union from 60 million, let's say now, to over 1 billion in 2025, and the number of people aged 80 or older, currently 50 million, will rise 3 times to 137 million by 2025. This phenomenon is connected with the cross-border movement of people in 21st century. What makes that private international law is of great importance in both in theory and in practice. We can also see new tendencies in civil and family law, as well as in private international law and international civil procedure. Additionally, I'd like to point the awareness of these problems has already led in some countries to a complete overhaul of the internal legal systems of so-called protection of adults, but this term is not precise, suffering from disorders of reduced personal abilities. What is, let's say, normal in this age. This phenomenon is also noticeable by other international organizations like United Nations, Council of Europe, and European Union. And we see the ideas and demands also of political nature to develop international standards of private law that would better fit so-shaped modern societies and properly secure both interests of older people as well as, and this side is also important, not only the elder people, but also us, as the other parties to, for example, contracts or other parties to the so-called third parties, other parties of legal relations. As the background to the speech on private law, also the comprehensive perspective of international public law should be taken into account. 2 examples from this year of great interest of international organizations. This is a report of Working Group on Aging from United Nations materials, date 31st May 2044. And the second is resolution adopted by the General Assembly of United Nations on 13th August 2024. As far as private law is concerned, I would like to share with thoughts on identification the topics the aspects which, in my opinion, are of great importance, and maybe they should be studied and researched deeper in the future. So I would like to start with challenges for private law, also private law in this era of structural changes in the European societies, especially European ones. And in particular, we see the growing participation of elder people in private and civil law transactions. Secondly, or even before the first thought, we should understand the specificity of the elderly person in the society. Lawyers tend to know everything and nothing. In my opinion, we should also hear to the sociologically, psychologically, criminologically, genetically points of view as the starting point for legal research regarding private law. As I've said, also the background of international law should be taken into considerations, as well as the political declarations for the future, both at national levels as well as at international levels. As far as the, let's say, selection, identification, the crucial topics, the crucial issues to study, to research, which are civil law institutions, and including acting and contracting with so-called third parties, I would like to mention not only the individual, it is important, but not only the individual situation, the individual status of a given older person, but also transactions, contracts, for example, torts, with the participation of so-called third parties. Then the issue of representation, including guardianship and curatorship and other legal institution, like an assistance or similar of a person, natural person, or even an institute or institutional body. Then we have another topic, another very important block of topics. It is a protection of dignity of a person, of an older person. The next topic and next issue important from the perspective of private law is protection against unfavorable disposals and torts. And then we have to connect it with other substantive law areas, not only the law on personal status, not only the, let's say, family law, law on contracts and law on torts, but also the rest of substantive law, procedural law, and private international law, including the effective right to court and to other procedural advantages. I would also to point the legal transactions with foreign countries. These are three aspects: the international jurisdiction, the international jurisdiction of courts. Then we have the issue, the question of the law applicable, which country's law is applicable, and then there is a topic of recognition and enforcement of foreign judgment or foreign decisions. The core issue is the proper or not proper, or let's say, in a broad meaning, a reaction of the legal system. What is the reaction of the legal system, understood as courts interpreting the current provisions and the legislator thinking or proposing the new provisions. We can see the phenomenon of more specific way of application of certain, let's say, old legal provisions, legal institutions. We can also see new interpretations of, let's say, old law. And the third aspect is the, let's say, desired or the legalata postulates regarding the relations with elder people. What could be the possible de lege postulates, both from national legislators and international organizations, and they could include comparative law researchers. In more detail, I'd like to present, but not too detailed, the new proposals, including the last year proposal of European Union regulation. So in May 2023, the European Commission announced two legislative initiatives, and they are called adult protection measures. This term is not precise, but of great importance, but very important because it shapes the scope of applications. In fact, it is not only the protection of others, but this is the name, this is the topic, this is the title of this Hague Convention, and after this Hague Convention, all those activities are called adult protection. It includes, for example, guardianship, curatorship, incapacitation or limitation of capacity, or other legal institution with similar effects. And European Union Commission proposed, firstly, truly speaking, the first should be mentioned, the proposal for a Council decision authorizing Member States to become parties to the 2000 Hague Convention on International Protection of Adults. And when all European countries will be members of this 2000 Hague Convention, the second proposal has its importance. This is a proposal for regional European regulation on jurisdiction, law applicable, and recognition and enforcement of measures and cooperations in matters relating to the protection of adults. What is the relation, what is the sense of those two activities? The European regulation, in fact, presupposes making the Hague Convention applicable in all European Union member states. So far, there are 14. Poland is, for example, not the party to this convention. We have signed it, but the ratification has not occurred so far. And the second, and this is from theoretical point of view interesting, but from practical point of view maybe a bit complicated, is the issue of supplementary European regulation, a regional one. The Hague Convention is a global instrument, also enforced in European countries, and the regulation is planned as the regional, let's say, regional modification of this Hague Convention. So regional modification and amendment to this Hague Convention as far as jurisdiction, international court issues, and law applicable, private international law is concerned. So comparing with the nowadays situation in Poland, those the topics are covered by Civil Procedural Code and the Act, the Statute on Private International Law. These are the Polish sources of law that apply to those topics, let's say, measures of protection of adults. And also the old one convention should be mentioned. Also the 1905 Hague Convention in force with three, as I remember, countries in Poland, as well as over 30 bilateral conventions which Poland has signed. Generally speaking, these activities and this part of private law is called judicial cooperation in civil matters. So it was named in the European nomenclature, in the European treaties, but in fact it means private international law and international civil procedure. And the key issues are domestic jurisdiction, designation of law applicable, and then the effectiveness of foreign judgments or foreign decisions on those measures of protections of adults. For example, guardianship, curatorship, similar measures. So the most important as a point of start with researching is the meaning of the term measure of protection, broad meaning of measure of protection. Many legal institutions known and different in legal systems and of European Union countries. This shows the general process of involving the interstate unification of law, which has been very intense in the area of foreign legal transactions in recent decades. And nowadays it has resulted in a kind of mosaic, or you can even say a kind of labyrinth of legal sources, both of domestic origin and Hague International Conventions origin, as well as European regulations that are applied in a given case. As I said, Poland signed the 2000 Hague Convention in 2008, but the ratification has not taken place. I would compare these proposals, to the current complex treatment of legal sources in the scope of child custody cases, including international child abduction. And we have also a similar, let's say, mosaic or mixture or labyrinth of legal sources. The 1980 Hague Convention, 1996 Hague Convention, then we have Brussels 2B European regulation, as far as many, from Polish perspective, bilateral treaties. This practice, as I've said, may be interesting from the theoretical point of view, may be positive from the merit, but can be also complicated and not easy to use in practice by practitioners. And the last thoughts about those proposals are the key importance of the concept of protection measures. So before analyzing those two proposals, we should have a deep look on the concept of protective measure, what it means from the perspective of Poland, Hungary, what it means from the perspective of Spain or Sweden. Generally, the convention may lead to the positive practical effects of simplification, because, for example, incapacitation on similar judgment will not mean in practice a full settlement of an adult's life or needs. It should be those combined term, those broad meaning of protection measure should be seen also from the reverse side, which is important from the civil law transactions point of view. It is, let's say, assistance to the adult concerned to return to participate in the society, in the transaction, and the aim is to protect him or her, for example, with the guardian or curator, assistant, court, or an institution. So the detailed observations are that there is a conclusion that the impact of Poland's accession to the Hague Convention could be evaluated as neutral or positive. But the concept of additional European regulation may give various comments, both positive and critical. And the general conclusion is that there is both theoretical and practical role of private international law as far as the topic of protection of elderly people in the society is concerned. It means the aspects of personal status, civil law, contracts with third parties, the representation, the procedure, litigation, and private international law. The need of detailed study means the study on changes of interpretation of current provisions. It's not easy, but some trends are seen in current jurisprudence. Then we have new legislative tendencies, also influenced by the United Nations conventions and the development of broad development of the concept of human rights. And then we have the issue, the question whether new codifications, domestic or international, should be taken into consideration. And the last, also procedural issues are of great importance. Also new technologies from the perspective of those us in the future, hopefully, elder persons, and let's say third parties, and the legal system, the legal transactions, the legal relations, as well as the court proceedings and the status as a part to the court proceeding. Thanks a lot for invitation once again and for the attention. Thank you.